Hello, everyone. You ever wonder why the government commissions all these weird studies about, the mating habits of fish or teenagers or, various weird art things that aren't grants for art, but studying these things? Well, I can give you one good reason right now. An example that I can't think of any other way to say it. Basically, is an example of what happens when the government does not investigate the lives of people and the not specific lives, but general cultural trends, things like that. Because when government doesn't do this in a law enforcement capacity, much like the Supreme Court justices barely getting a handle on pagers and not being able to talk about, have experts there to talk about text messages and things like that, and modern phones. Not have knowledge they could draw upon for this. And I understand there's only a limited amount you can do this, in a trial where the information has to be fair for both sides. But I'm kind of babbling because what I'm looking at is just insane. The title of the article is Seventh Circuit Rules Dungeons and Dragons a Threat to Prison Security. The Seventh Circuit didn't make the ruling. A judge in the Southern District of Indiana made the ruling, a federal judge. Let me just read this a little bit. Wampum's long-serving disruptive group coordinator, Captain Bruce Muraski, received an anonymous letter from an inmate. The letter expressed concern that Singer and 3 other inmates were forming a D&D gang and were trying to recruit others to join by passing around their D&D publications. D&D is Dungeons and Dragons, for those of you who are not gaming geeks, and touting the rush they got from playing the game. Muraski, Wampum's expert on gang activity, decided to heed the letter's advice and check into this gang before it gets out of hand. And the article goes on to talk about how the other players take direction from the dungeon master, and that could be a leadership role. And there was another case similar to this, where they were talking about the maps used in D&D could be used to plot escapes. And I really, really am going to try and not go beyond what I've read. But you'd think, if they wanted him not to be playing D&D, and for some reason they just wanted to be pissy about it, hypothetically, they could have come up with a better excuse. They didn't want him clogging the toilets with the dice. They thought the 4-sided die, which looks like a little four-sided, a 3-sided pyramid, is a good way of looking. I mean, that's not a good way to look at it. Whatever. It's pointy. They could have used it to stab guards in the foot. I don't know. They could have come up with some way of making this less idiotic if they had some kind of expertise to draw upon. This is what the judge said. The question is not whether D&D has led to gang behavior in the past, because they had demonstrated, that it hadn't, whatever. But that's not the question. The prison officials concede that it has not. The question is whether the prison officials are rational in their belief that, if left unchecked, D&D could lead to gang behavior among inmates and undermine prison security in the future. I would argue that it would be easier and more subtle to form a conspiracy with a card game than with D&D. There's too much talking in D&D, too much to be overheard, and too much information that is let loose to the people around you. Anyhow. Singer's affiants demonstrate significant personal knowledge about D&D's rules and gameplay, and offer their own assessments that D&D does not lead to gang behavior, but they lack the qualifications necessary to determine whether the relationship between the D&D ban and the maintenance of prison security is so remote as to render the policy arbitrary or irrational. Of course, many of Singer's affiants are present or former inmates, but their experiential expertise in prison security is from the wrong side of the bars and fails to match Muraski's perspective. The expertise critical here is that relating to prisons, their security, and the prevention of prison gang activity. Singer's affiants conspicuously lack such expertise. So, because the government has no experts, or is not willing to call an expert on game theory, because they want to, and this is what part of the nature of the legal system. I mean, the judge can't call his own witness, can't call his own impartial whatever, to say, tell me about this game. You know, tell me about Jerry Falwell talking about D&D in schools, and you know how it was so evil and it was causing children to turn satanic. And did that ever happen? Did anything come of that? That would have been a nice thing to have. I think part of this is just because of the adversarial nature of our system, that it's not the court attempting to arrive at truth. It's two competing narratives fight it out in front of a judge and jury in some cases. And I'm not arguing that the prisoner should have rights to D&D and whatever, because it's a game. You know, suing for it under the First Amendment was probably just as silly as saying that it was a security risk. I don't see either of those as supportable claims. I am not a lawyer. I can't find anything that's not ridiculous about this, so I'm just going to shut up and pass this on. I mean, I can... Wow. Thank you for your time and attention.